Okay, just so you know, on those surveys, the answer is 5. It's kind of a test. If you just answer 5, you're good. Let's see. Is that going to make
There should be a button on top there just to.
Can you hear me? Do you need that, or do I talk loud enough? It's better.
It definitely helps too for the online.
Oh, good point. Okay, great. That worked. All right, so we are going to talk today about, I know a lot of you have called me and said, you've had a situation and what happens now, and a lot of times that's the last you ever hear about it. And so we thought we'd go over today some of those, what happens, the process that we go through after someone gets hurt. The most common question I get when a county person calls me from a fair and events is they'll call up and say, I just don't understand how they can file a lawsuit against us for this incident. The county people will say that to me. They'll say, I know, especially in a small county, they'll say, I know Bessie, and I've seen her at church, and she's not hurt. She claims she got hurt at the fair, she's not hurt. How can she sue us? Well, the minute these people, anytime you have an event or a fair or anything, the minute these people enter your property, they have a reason to sue you. I mean, that's just the way it is. They can claim anything they want to. They can claim they fell down. They can claim they tripped on a power cord. Whatever they want to claim, it's just the way it is. So you're just going to have to know that there's people that are going to you have to look out for you and look how to make money. So today, instead of overwhelming you with all the legal issues that USIP has to deal with, when it comes to fairs and events, the only kind of really lawsuits we get are state claims. And so a state claim is like general liability, slip and fall, negligence. It's something you did wrong. It's, they were at the fair and one of the cows kicked them, or a horse kicked them, or they tripped on a power cord, or the music was loud, damaged their ears. I mean, the list goes on of all the things that they've sued counties for when it comes to their events, especially their fairs, rodeos, kind of things like that. They're all state claims. They're claims that they don't have any federal laws that were broken. So we're not going to talk today about any of those. We're not even going to talk about auto accidents. Auto accidents kind of fall in the same category as state claims, so they're going to be state claims, but we're not going to get so much into that as much. But just so you know, auto claims are state claims. When you get into public officials, employment liability, and things like that, your sheriffs, that's where you're going to get most of your federal complaints. So they're the people that have their rights violated. That's because they've broken federal laws. So, but we're not going to do any of that today. We're not going to cover any of the federal claims. Because really that doesn't affect the fairs and events. You're just not going to get, that would be if your sheriff came in and arrested someone and violated their rights, and that probably wouldn't be your department anyway. So we're going to skip it, plus it's a lot of information if you go over state claims and federal claims all in one meeting. So today is just going to be state claims. Now, I'm going to start off with a little entertainment here. There is a purpose for this. Okay.
Can you come up there?
Well, am I going wrong? No, here we go. Oh, maybe right here.
Lisa Broderick got me $1.7 million.
Thanks to Lisa Broderick, we were awarded $2 million.
Wait. Those guys got how much? We've got you back. I, Lisa Broderick, have 14 years of law experience, and I graduated top of my class at Yale.
And I am also a lawyer.
I burned my tongue on hot coffee. Thanks to Lisa Broderick, I don't have to work anymore.
Dale sprained his ankle at the mall.
And now we're set for life.
Cement truck crashed in my living room and dumped cement all over me. I was trapped in concrete for 3 days. Firemen had to chisel me out. Now that I think about it, $6,000 seems pretty light given the severity of this accident. I'm not sure Dan's did a good job here. As a lawyer, I love having a personal connection with my clients.
My favorite part about being a lawyer is that there's a real-life policeman in the courtroom. You can touch his gun, but you can see it.
He did touch his gun, and it definitely affected the case.
Lisa was smart, professional, and answered all my questions.
Lisa came to our home every day and drove us to the courthouse.
Dude, Dan showed up to court an hour late wearing 2 different New Balance sneakers. At one point, I'm pretty sure he called me Your Honor.
You know, people always ask us, how in God's name did you become partners?
I first met Jeremy Gans when he generously gave my father his kidney.
And then she hired me when I gave her husband my other kidney.
This guy's walking around with no kidneys. And that explains why I kept going cross-eyed and blacking out.
I guess you could say Lisa was a bulldog in the courtroom.
One time after he blacked out, I had to present my own evidence. I had video of the whole crash. But when I showed it in court, Gans had recorded over it with his audition for that TV show, Naked and Afraid.
When Broderick gave her closing argument, the judge and the jury actually applauded.
After mine was over, Gans followed me back to my hotel and asked to borrow 5 of my $6,000. When I said no, he locked himself in the bathroom and called squatters' rights. I had to hire another lawyer to evict him. I am in so much debt right now. I'm Broderick and Gans. We'll never stop fighting for you.
That's right. And my God!
You're probably wondering what that really had to do with anything. It has a lot, surprisingly enough. When we get a lawsuit filed, we have that wide of a range of the lawyers that sue for counties. We have great lawyers, lawyers that have a lot of experience, and we have some that are just terrible. And we do. When we get a complaint in, one of the first things I look at is, who's the plaintiff attorney? Do we have a real problem here, or is it going to be someone that doesn't really know? But for example, Siegfried and Jensen, I know you've heard of that firm on them. I hope none of you have a great relationship with them, but when I see that Siegfried and Jensen are on there, I know that there's never going to be a trial. They're not trial lawyers. They're high-paid adjusters. So is kind of Robert DeBry and a lot of the TV ones you see. They're more or less high-paid adjusters. They want to do volume. They want to get the claim, submit it to the insurance company, get a settlement, and be done with it. Those firms don't like us at all because they know that the counties rarely just give in and pay a claim. There has to be extremely straightforward liability on that, and we don't pay them very much because we can kind of call their bluff that they're not going to go to trial because they just don't do that. But unfortunately, depending on the attorney and the experience they have, they can drive the attorney costs through the ceiling. When you see like sites on TV, or you see there's an attorney named April Hollingsworth. When you see names like that, you know that you're going to spend, your expenses are going to be way higher. They're going to fire frivolous things. They're going to make up stuff. They're going to lie. I mean, I don't know if you've watched the impeachment hearings, but people lie. They just lie all the time. And unfortunately, That's what happens when we get these cases. And if you get an attorney that will embellish the claim and lie and make up things, unfortunately, it makes things really expensive. Let's see what happened. I included this in the package just because this shows, and we don't go through, we're going to kind of go through this, but I just wanted to have it in your packets just as a reminder of what happens when a lawsuit comes in. And it's just kind of the steps we take and we do this. So the scenario is you had what do you call them, a guest at your event, and there's a horse out there, and they went over and they decided to pet this horse, and the horse kicked him and knocked him down, and so they decided to sue the county. Now, even though you say to yourself, well, we don't own the horse, it's not our horse, it's someone who brought the horse. Doesn't matter. A lot of times they'll still name the county because they know that the owner of the horse might not have as much insurance as the county. So they'll go ahead and name the county in the complaint saying that we could have done something better. The county could have had a sign at the fair saying keep away from the horses. So anyway, they'll name as many people as they can in the lawsuit. There's their first technique. Can you see this mic can be constantly in your way over there? I guess this is probably too small to read, but as long as it's in your packet, you can look at it. Okay. So a claim arises. Lady's being kicked by a horse. What happens now? First of all, the person who's been kicked has 1 year to file a notice of claim with the county. And what I mean by notice of claim, that is not walking into your fair and event center up to your manager or whatever and saying, hey, by the way, I got hit by a horse. That's not a notice of claim. They have to do an official written notice of claim. And we're going to go into the details of that in just a minute. So these are going to be based on Utah code. And so I put those in your packet so you know. This one here, when a claim arises, 63G, they have 1 year to file a proper notice of claim. It has to be directed and delivered to the county clerk or a designated recipient. So if in your county you don't want it to be the clerk, you can have the commissioner, you can have, as long as you designate it on the website that who to receive your notice of claim, it can be that person, or it could be now, they just changed this recently, or it could be an elected county official, executive officer, and the county attorney by hand or mail. So there's kind of different ways that they can do it now. I think that the plaintiff's attorneys got tired of always having to try to figure out who they needed to serve. So for them, it made sense that they just serve an executive officer and the county attorney because they know that that's who they're actually going to be working with. So they kind of did that. The county has to respond now within 60 days of getting that letter, that actual notice of claim. If it's a proper one, that fits all the criteria, the county response has to be within 60 days. The county attorney has to respond to it now. In the past, up until last year, a lot of you would send in the claim to me, and I'd send a denial letter, perhaps, saying, we didn't own the horse, the claim's denied. Can't do that anymore. The county has to be the one that denies it within 60 days. And we're going to go into detail about what the county attorney has to do, but it's going to be your county attorney. So if the county attorney starts saying, well, why do I have to deny it now? Say, well, because Utah code made it so you're going to have to deny it. If someone just calls me on the phone and says, yeah, I was kicked by a horse, I may verbally tell them, hey, that's not going to be covered by us, just to try to discourage them. But as far as written, the county attorney is going to now have to respond. We'll go into more detail about that. And then, that same lady that's been kicked by the horse has 2 years to file a complaint from the date she was kicked by the horse. That's very important. Not the day she decides to sue, 2 years, or the day she hires an attorney, but actually 2 years from the date it actually happened. The nice thing about state claims is they always have a certain date they happen. You got in a car wreck on this date. You got kicked by a horse on this date, which is nice for state claims. Federal claims can be a little more vague. They can be, well, he's first started blowing the whistle, saying that they were fired for some reason. The dates vary. But the nice thing about state claims is you know exactly when it happens, so you don't have to worry about that. Okay. So what is the notice of claim? So what is this plaintiff attorney? What are you looking for when you get a notice of claim in the mail? So this is going to be 63G7401, 3. So the notice of claim shall set forth first a brief statement of facts. They have to say, on this date, I was at the fair, I went over to the fence, the horse kicked me. So they have to state what happened to them. They have to say the nature of the claim. They have to say, I'm suing because I broke my leg. They have to give specifics of what their injuries are from the event. The damages incurred by the claimant, as far as they are known, at that point. So at that point, they have to submit, if they had a broken leg, they have to submit the medical bills for a broken leg and things like that. Unfortunately, we're seeing a trend right now where plaintiff attorneys are now, as the claim starts going, they're throwing in that, they're starting to suffer from a brain injury. Unfortunately, that doesn't need to be in the original notice of claim, and they can add that later, because this is as they're known. But sadly, we're getting a trend right now, our plaintiff attorneys are making up these brain injuries, because, well, ever since they got kicked by a horse, they're depressed and all that. Well, they used to just say, well, that's part of life. But lately, plaintiff attorneys are saying, that's a brain injury. We've got a psychologist that said ever since that event, they've had PTSD, they've had, we found that they bumped their head on the ground when they fell, and we didn't know it at the time, but they blacked out. And unfortunately, you have witnesses that say, they never blacked out, what are you talking about? But they can claim it, they can still claim it, and that's what makes it very difficult to have a claim and lawsuits, and that's why they get so expensive. And I'm going to go into how much this costs, because I know a lot of county people will call me and say, I was just kind of curious, how much has this cost us so far for this lady that fell down and had no injuries? And when I tell them, we're into about $150,000, there's this shock at the end of the phone call. I mean, they're just, are you kidding me? And that's, we haven't even settled it. We haven't even concluded the claim. We've just been defending it, hiring experts. If we have to hire a brain expert, those are at $500 an hour for their services. So it can get very expensive. Finally, in the notice of claim, they now have it. They have to name the government employee, someone that was involved in causing this claim. That's good in a way, because then they can't just say, it happened, and it turns out nobody witnessed it, nobody saw it. They have to say, this county employee was there and it was over security or whatever. Unfortunately, it's pretty easy for them to find someone to blame on, whether it's just a security guard, someone from the county. Okay, so here's the response. The county attorney, so you need to get that. If the county attorney didn't get a copy of it, make sure you get him a copy of it. If they happen to serve it on the county clerk, the county attorney gets it. He has the 60 days, and he'll do it in writing. The reason actually I liked this part of the bill is sometimes the county would call me up and say, hey, we had an accident on the road, and it's not a county road, so can you go ahead and deny the claim? Well, I don't know your county, I don't know your roads, I don't know what road is, and so for me, I just kind of do a very generic, it's not, we're denying the claim because it's not a county road. But all I'm going by is what the attorney told me. So I've actually liked how the county attorney has to respond, because the county attorney can get more detail. He can call the public works department and say, who plows it, who maintains it, who fills the potholes, and he knows exactly. And so when he writes his letter back, he can say, this is the reason it's not involving us, blah, blah, blah. So I kind of like that aspect of it. The only twist, though, to it is if the county attorney figures out in that meantime that it was the city. It's a city road owned by the city. He unfortunately has to then say in his response, and it's not only not us, but it's actually parent and city. And kind of point the finger at someone else. I don't like that because we're going to have cities and people pointing the finger at the county. And even though they're not right, we've already had that happen where someone said, sue the county. So the next thing you know, I get the notice of claim sent to me from the city, send it directly to me, say this is one of yours, and then I get looking into it, and it's not even one of ours. So the city made a mistake in sending it to us, and it wasn't even us. So that is a problem. I do like how the county attorney denies it. And the clock started ticking on the date of the accident rather than the date of the letter. It used to be by the date of the letter that the attorney sent out, and now it's by the date of the occurrence. So we actually gained technically 60 days on that. Okay. A complaint is served on you. Complaint comes in, you find out it's in your county, it's a fairs event, something happened in your event, lady got hit by a horse. They have 90 days to serve that complaint. So just because it's been filed on you, it doesn't mean it's actually been served. You'll probably know about it the day it gets served on you. But every once in a while, a plaintiff attorney will send you the complaint, and if you look on the front of it, it has no judge assigned to it, and it has no case assigned to it. So you know that this is a threat. This is not an actual lawsuit. It's just a threat. But within 90 days, if you do nothing and just ignore it, more likely in 90 days, it's going to go ahead and sometimes we walk away. Sometimes the threat, we call their bluff and they walk away. But if they don't, they then go ahead and serve it on the county employee. So here you are, you work for the fairs and events, and the law enforcement shows up and serves you a lawsuit. You look at that and you need to immediately get it to your county attorney's office. You want to get that into it. Because we only have 20 days from that to answer it. And so if people sit on it and it sits on the desk for 20 days, we get in trouble. So 20 days for us to respond to the lawsuit. Now, if you're the county employee that's named in the lawsuit, the county attorney will ask you to put in writing that you're requesting an offense. You want the county to defend you. And that's just pretty straightforward. Obviously, you don't want to get sued for something you're doing at work, so you want the county to, you pay for it, defend it, take it away from me. Here's my letter, I'd like to do that. The county attorney will give the complaint to the risk coordinator. That's someone like Joanne Evans, for example, is the risk coordinator in Shady County. You give it to her. She's our contact with Houston. So she gives it you give it to her, and she's going to enter it online and send it to Houston. We get it, and technically, at that point, a lot of times the county attorney will tell me, hey, of your defense team, I kind of wanted to assign to so-and-so. But if they don't, I'll probably send a quick note back to John Sturmer. He's not there anymore. Stephen Foote, whatever. Yeah, I'll send a letter back saying, hey, who do you want this assigned to? Because now the complaint, we let the county attorney decide who he wants to defend it. Because technically, the county attorney has a statutory obligation to defend a lawsuit. So what we do is we assign someone to assist him in that duty. And so really, it gives the chance for our defense attorney to take it over and take it off the plate of the county attorney, which is a good thing for the county attorney. So, as you see, it's assist the county attorney in the defense of the complaint. So we want to make sure they get along. We want to make sure that our attorney and their attorney get along. Okay, so that's been served on the... And now the lawsuit begins. The complaint is answered by the attorney. There's a county investigation. When it comes to that, you want to keep very good notes. If you have anything that happened, if you had someone say to you, hey, I saw that, and they were aggravating the horse. They were purposely annoying the horse, hitting it, whatever. You want to do a really good investigation, because that is where you can save the county a lot of money. Because if you have a really tight investigation, you know exactly what happened, when it happened, why it happened, you got the facts, the person that you got that fell down, the minute you know that they are going to do something, how to put it in writing. Because then they try to change their story a lot. You know, they get a plaintiff attorney like he's on TV that's going to say, hey, did you hit your head? Oh, yeah, maybe I did hit my head. So it's better to give them right then, hey, just tell us what happened. Oh, I got kicked by the horse and I got a bruise on my leg. Just is kind of nice to have as much information from them the first time. So later when they're in a deposition, oh, you know, back in this accident, you told them that you didn't hit your head and you didn't fall down. So this is probably, if you get anything out of this presentation, that is it. We need solid county. Whatever happened in that fair or event, document as much as you can. There's never too much. That could be media statement, interviews, etc. Because then what happens is our county attorney gets the complaint, or not our county attorney, our defense attorney. He gets the complaint, and the first thing he does is looks for, how can I show the county had nothing to do with this? And if he's got a good investigation from the county, he files a motion to dismiss right off the bat. He said, we're going to just file a motion to dismiss this complaint. It's bogus. It's no good. Guess how much that could cost? That's going to cost, I'm being actually conservative, a lot of these amounts I'm putting in here. Just that could cost us $20,000 to $30,000. Just to have county dismissed out of a lawsuit right out of the gate. So just to give you an idea of what this costs. Okay, so he files a motion to dismiss. The court comes back and says, no, there's some facts that I'm not real comfortable with. I think that, you know, so what he says is he needs some more discovery. I think there's some things missing, the story's not adding up, there's some laws that maybe weren't quite clear, and so he does not dismiss the claim. So guess what happens? We go to the next phase, which is discovery, where we have to go in and actually do depositions and interview people, come to the county, take scenes, find the horse, take pictures of the horse, hire an expert if we need them to claim that they had a brain injury. We start having to do subpoenas and bring people in to testify, witnesses that we saw. So you can see, it's not going to be fun for you if we get to this phase, because they're going to be bugging you. They're going to be bugging you for, they're going to want you to leave work and come in and take a deposition. And if you've ever had a deposition taken of you, it's not fun. It's, you know, someone's going to be drilling you and you feel off guard, even though you're completely innocent. There's just a certain amount of fear that comes with it. Okay, so at the end of that, the attorney gets that all together, all those depositions, witnesses, and he files what's called a motion for summary judgment. And that is, he puts it in front of the judge and says, here, look, here's the facts that you were concerned about. I've cleared them up with this evidence, I've cleared it up with this witness, I've cleared it up with this and this and that. Here it is, and they send it in, it's 200 pages long. And the other side files a motion, summary judgment in defense of it, saying that it's wrong. So you have both sides of it, one for it and one against it. And because technically the plaintiff attorney can file a motion for summary judgment first. So that's why I say there's one that's saying we want it dismissed, and one that's saying it's not, depending on the situation. But guess what? Just to get to that phase, we're somewhere between $85,000 and $125,000. This is for a lady that got kicked at your fair. That you saw that next week bowling in a bowling league. Guess what? It's just the way it goes. There's just no way you can stop it with the courts, especially lately. The courts have not been friendly to the counties. We have a couple of judges out there that have just not been friendly to the counties. Okay, so motion for summary judgment happens, and again, the judge says, no, I think that a jury needs to hear this. We need to go to a jury. We need to bring in the witness. We need to bring in the person who's injured and all that. So, what happens then is typically the court will call us up and say, we want you to do a mediation. Have any of you been involved in a mediation? Anyone been involved? If you're ADHD, they're the worst. It's just that they're very hard to sit through. But what happens is, okay, so the court says you have to do a mediation. And I'm going to tell you what a mediation is quickly, and so you get an idea what it's like. But let me just explain one thing quickly. A lot of times, the counties will be upset saying, wait, you're going to go to a mediation, because the idea of a mediation is to settle the claim. The court is trying to force you to settle the claim. That's what mediation means, basically. They're wanting to force you to do it. So I'll get a commissioner, I'll get a county attorney call me up saying, what do you mean you're going to settle this claim? We did nothing wrong. And we have to explain that it's kind of a mandatory. Sometimes it is actually mandatory. The judge will say, you will do a mediation. Sometimes they'll say, I would like you to do a mediation. Well, the reason we go ahead and do a mediation when they say we'd like you to do one is it doesn't hurt. It's nothing that can be used in the courts. It's all kept private. No one hears anything about it. And it gives us a chance to kind of fill out the other side. It gives me a chance to see the plaintiff and see how they're going to look at a jury. Are they going to come across to a jury as a good person, a bad person, an honest person? So we really do it to size up the plaintiff. And we go with no intention to actually settling. But when we get to the mediation and they come in and they want $500,000, I'll have the authority of the county attorney. You know what? I'm going to go ahead and have some money, maybe $10,000 authority, just so that I can make some offers, so that it goes when it goes back to the judge saying, hey, they didn't settle in mediation. The mediator can say, they came in good faith. They came with a good faith. They had money. They came with good faith. That's important to establish with the judge. That we're not this hardcore. Hey, we won't listen to reason at all. We at least say, we'll hear you out. So we usually go to these mediations. So what happens is you get to the mediation, and you'll have 2 rooms. And they'll put the plaintiffs in one room, and then the defense in the other room. So in the other room, there'll be the county attorney, me, the defense attorney, whoever wants to be there from the county. So the sheriff's been there, the commissioner's been there, risk managers have been there. We're all in one room. The plaintiff and their attorneys are in another room. And they've kind of done a smart move recently. They start separated. It used to be you met together, and the mediator would have each explain their cases, and it would turn into an argument. And it just became non-productive because it set people in a bad mood. So luckily, I think Yusuf and others put enough pressures on mediators to say, don't do this. Let's have us each in one room so that we never have that anger. We start out on a good, clean sheet. So now they go in with the plaintiff attorney first. And they want to hear exactly, what is your case, what is your bill, why are you suing, blah, blah, blah. He talks to them, and then he That's usually, seriously, it is 2 hours. It is, you'd think it'd be short, but it is 2 hours. At least the first round, because the plaintiff attorney has wanted to hear their voice for a long time. And they will come in and they will just cry, and they'll go on and on and on, and it's just, we just sit in the other room for 2 hours, at least. Then they come in our side and he says, here's what's going on. We've got a plaintiff that, I mean, and the mediators a lot of times are straightforward. They'll say, the attorney's lost control of this case. He's got a client that she's just got in her head, this horse has ruined her life, and she's just almost suicidal, and then we'll get our chance to say, look, but we didn't do anything. It was even our horse. And he says, yeah, and so sometimes we'll actually delay a little bit to make the plaintiff think that we're really feeling sorry for her, And so it's a game. It's kind of like a chess match, mediation. And so we kind of developed a strategy, say, look, if we send back $10, it's going to make her more offended. It's just going to look bad. We'll send back $1,000. So that's where it begins. And then they'll come back. And those first couple of rounds are kind of long. Usually that's about to noon by then. But finally, when you realize that the other side actually wants to settle, and we actually want to settle in a case, let's say, maybe it's an auto accident where we rear ended them, and we actually do kind of want to settle, things start moving quicker after they starved us. They usually don't give you lunch because they want you to be hungry. They want you to be a little bit, let's get out of here, a little anxious. So they start, no lunch, you're all sitting there, no water, you're sitting in the room, you're getting a little tired of sitting, and then things start to move. They'll come back, and it gets down to just dollars. They'll come back 200,000. We'll go up 10,000. They'll come up 150,000. And the mediator just goes back and forth trying to come into a number. And it only takes me about 2 rounds to know exactly what their authority is. Because I've just done it so many times over 30-something years that you can see by their second move, they do it as a percentage, and you can kind of see, oh, okay, that's where they're headed. They're headed to 50,000. And it's amazing how quickly you come to that and see. And so typically we kind of know if it's going to settle pretty quick. Because if I know it's going to be 50 and I only have authority from the county for 20,000, I know it's not going to work out. And so it gives me incentive to, hey, let's speed this thing up. And but if not, I think, hey, if we have 50,000 authority and they're 2 million, and I can get them to 50,000, I'm going to take all day to do it. Because it's going to take an all day to get them from 2 million to 50,000, because you got to play chess. You got to kill off the pawns slowly, all the way down until you get them. And you do that mathematically by making your percentages a certain percentage too. That's going to make you the max you can go is 50,000, because you never want to do an offer bigger than the last offer. So anyway, it's a lot of math, and it's actually probably the favorite part of my job is doing mediations in a way, even though I'm ADHD and I get frustrated sitting in the room, but it is the most interesting. Okay, so at that point we settled, or we've been told that we're going to move to trial. It didn't work out, we moved to trial. Look where we are. Now we're at $150,000 to $175,000. Just, you can see, it's not fun. Okay, so then we start preparing for trial. Trial usually costs us about $30,000 for defense costs to get an attorney ready for a trial. We've had trials where the night before our defense attorney's husband dies of a heart attack. Boom, trial's bumped, and we basically start over again. We've had things that have happened that made trials so expensive. Depending on the situation, we will probably have what's called a litigation meeting, where we bring a bunch of our county attorneys together and say, do we really want to go to trial on this? Or do we want to maybe look at this a little deeper? If the litigation committee says, county attorneys say, yeah, you know what, maybe we do. After that mediation and that information you learned, maybe we do want to go and let's say, let's go to the board and see if we get some more money. So there's that chance that we may settle before a trial between the mediation and the trial, depending on some of the facts that change. But okay, then you go to trial, and they can do, a lot of times they can do either a bench trial or a jury trial. Typically, state claims are jury trials. And the difference is, when you have a bench trial, the jury, you have a trial, but the jury is the judge. You don't have your panel of unbiased people sitting there. You're just going to talk to the judge. The reason you want to go in front of a judge sometimes is because maybe the issues are so complicated that the average Utah that they're going to get a jury from, it's going to be over their head. You know, it's a violation of someone's civil rights. It's got these federal issues, these state issues. So you may want a judge to handle that trial. But if it's an injury claim, all of you can relate to that. You've all fallen down. You've all been in an auto accident, more than likely. You can kind of relate to what it is. You've all had kids break their arms. You kind of know what to expect. So those you want to have a jury trial because you want to go in and say, really, you got kicked by a horse, but you want $500,000, you want $1 million. My kid's been kicked by a horse, and I just told him to get in and clean up and wipe off his boots. I mean, so you get that. You get jury people like that come in and say, what a joke. It's not that big of a deal to get kicked by a horse. So they come in, they have the jury. When they first come in, they've pulled a bunch of people from the county or the state, depending on the situation. But you have these people come in and are future jurors who've probably been called to jury duty. The jury comes in, and the state will eliminate a bunch of them right off the bat. Like, they'll first say anyone that works for county fairs and events in this room, and those juries will just, if they raise their hand, they're just dismissed because they might be prejudiced towards, fair events because they work for them. Things like that. And then each attorney, they kind of tell about each person and kind of eliminate it, get down to who the jury is going to be. So in our case, we want to find people that are the guy that works on the ranch, has 9 sons, and he kicks their butt out at 5 in the morning to go milk the cows. And we want that kind of guy on the jury because he's going to be more likely to kind of says, wait, you're giving this guy money because he got kicked by a horse? So, whereas the other side, they're going to want the real snowflakes. They're going to want the people that, wow, I think I broke a fingernail. I think that salon should give me $1,000 because they broke my fingernail. That's what they're going to want on the jury. Okay, so the trial begins and the trial ends, and it either they get this, they come back with a zero verdict, or they come back with a judgment, and we got to pay it. Well, at that point, look where we're at. We're getting up to close to $250,000 to get to this point. And it's getting expensive. But guess what happens? An appeal. Someone didn't like the verdict for some reason. Someone feels like someone was prejudiced, or a witness said something they shouldn't have said, or whatever. And they file an appeal. It can be done by either side. So if we lose, if we got a judgment of $150,000, we think there's no way. We can appeal it. They can appeal it. It then goes to the appellate court, and the appeals court looks at it, and they can either, affirm it. If they affirm it, it's great. The case is over and we're done. We either pay the $150,000 or we won and we walk away, which I'll have you know, typically we win these and we get them affirmed and we're done. Sometimes they reverse them and send them back to the court saying, I think you need to work on this more, to the judge that's originally involved. Or they've sent them back for a new trial. Now, that is a disaster. We've had one. We have a couple right now that have gone back to have a new trial. And one that's technically had 3 trials. And that's what I was talking about, that video I showed at the beginning. It was one of those attorneys that just wouldn't let it go. And she somehow talked the judges into letting us have a new trial and new trials and coming up with these crazy ideas of why the jury was tainted or whatever. We've had new trials, and then you're talking $800,000 on one that we had that happen to in defense. So we hope that we just go typical state claims, that doesn't happen. They're usually, at this point, either dismissed with prejudice and we're done. And that's a judgment is rendered and we're done. So that's a good thing with state claims. They're not quite as complicated. Now, I don't know if any of you are ADHD or if you've ever sat through a trial, but this is just kind of a funny to wake you back up a little bit. I'm sorry, my presentation, the topic is not the most exciting. And Alex, I may need you to run up here and fix this. I'm going to give it a shot, though. Let's see. What do we got? No, that's right. I was going to see I was going to show everyone how smart I am, and it's not working out so well. Now, think of you as being me, and I'm ADHD, and I want to get done, I want to go, be done. This is mediation in a trial. This is what it's like in my mind. Every time I go.
Nothing can stop me now.
So as the attorney's in, I'm out of here. It's the end of the day. It's 4 o'clock. I'm going. That's me.
All right.
I wanted to let that up, just so you know. If he thinks, he's going, this day is over. He's called for claim.
Say, Langdon, where's the fire?
a mediation or a trial, that's how I feel. You just sit there and go, I don't know if you watched any impeachment hearing. I can watch that for about 2 minutes and I have to change it because it's just that over and over. Something's playing there. That's for my next routine next Or YouTube, be careful, who knows what's on the next, right? Thanks. But when I get into mediation, sometimes you want to go into the other side and just shake it and say, what is wrong with you? Let's just settle this thing and get rid of it. I can't believe you're doing this. But unfortunately, we're stuck with, we have to be very patient, very calm, very understanding because we don't want to get emotionally charged people. Because if you get emotionally charged people, and it can be the plaintiff attorney as well. We have a plaintiff attorney, I won't say her name, I won't say her name, but April Hollingsworth. I'm not going to say her name. But she gets so emotionally charged in her cases that we can't ever get anything reasonable out of it at all. And we end up spending, the cases go forever. And if you get her and Judge Shelby, I wasn't going to mention his name either, together, it's just a horrible combination. And so unfortunately, we are going to get sued. And we just have to know it's going to happen. And that's why you have the pool, just to protect you from these things. They are expensive, but you just have to know that that's just part of running fairs and events. And are there any questions? We just have a couple more minutes. Any questions on some of these? Because I know most of the time I get a call from the county, it's just crazy. They just don't understand why they're getting sick. Yeah.
On our facilities, we have a sign that says attention, you assume risk as you enter this because of the events and stuff. Does that save the county?
It helps. It doesn't guarantee anything. Because like I said, you get this attorney that has to fight it. But there's been some really good decisions come out about that. So Snowbird Ski Resort, years ago, they started putting on their ticket, a waiver right on the ticket. And so all the ski resorts started doing that. Well, a skier was coming down the hill and got hurt and tried to sue. And they took it to court and said, here, right on this ticket, this waiver, that we're not responsible for his injuries, thrown out. So the judge threw it out on a motion to dismiss without any other evidence because it said right on the waiver on the ticket that he had that we are not liable for injuries that has happened. And so that's starting to happen more and more. And then there's also just, foreseeable. I don't know if you saw it in the news, but Wasatch County had a derby where, cars you expect to go to derby, and they had the tickets with the waiver on the back, because now everyone does it. So yeah, you should definitely have signs and waivers on the tickets. Anywhere you can, it says we're not responsible for injuries. If you're here, you're on risk. The Jazz, that's another one that's really big on it, because there's so many times a player will fly into the stands and hurt someone, or things like that happen, and so they have these waivers. When you come to our event, sue us, starting to think saying, by accepting this, you're not going to sue us. So Wasatch County was a perfect example. They had a waiver on the ticket, a derby. Derby's happening, and the cars, what do they do to derby? They slam into each other, right? That's what you're paying to see. Well, the weirdest thing, these two cars hit each other, and another car, and they're just kind of pushing on each other. Well, the weight of the cars pushing on each other caused the drivetrain to just start to bow like this. Have you ever seen a piece of metal when it's bowed like this and it wants to go back to the way it was? And all of a sudden the car leaves? Well, just like that, boom. And you can look it up on YouTube. I think I showed that at one conference. But boom, this drivetrain went flying out of car and landed in the audience and broke the lady's leg. And she was from Las Vegas. Nothing about Las Vegas, but she immediately had a lawyer. She hired a firm that I'm not afraid of in Provo, so that was the good news. I saw that it was one that we aren't afraid of. And we went back and forth. We actually never assigned that to anyone. I just had to explain them over and over. You're never going to win this. I mean, how are you going to get a jury to believe that the county knew a drivetrain could get pressurized and blown out into the audience? There's just no one on a jury is ever going to buy that that was a reasonably seen event. So there has to be some sort of reasonable, did the county, could they have done something better? Whereas Weber County had a gate, and they let some people come up and they were sitting on the gate, and the announcer said, "Hey, you need to get off the gate," and they didn't kind of really force the issue, and a car went over and hit the gate, injured these two guys that were on the gate. And it wasn't reasonable that the county didn't immediately just stop the event, get the guys off the gate and continue. And so we actually got paid on that one. So you have to show that a reasonable person would expect it. Would a reasonable person think a horse is going to kick somebody if someone's, yeah. So that's why you guys do the best you can to keep the horses. You don't let them walk around in the crowd. Because so as long as you're doing what's reasonable, you're going to be protected. And any other questions? John usually has a great question for me that throws me off guard. What is it?
I was just going to say, with the waivers, there is one sign that's really important, and that's in the statute. It specifically says that if you put up a certain sign for equine events, then you are absolutely immune from lawsuits for equine events. So all of you that have, of course, equine stables and facilities and stuff, and not just at the fair time, but have it up all year round, so that when people are coming and using your fairgrounds for equine use, as long as you have the sign up that says what it requires in the statute, you can get sued for it, but that's where Corey talked about the case will just be dismissed. That's what will happen. As soon as the judge looks at it and says, it doesn't matter, we don't need to take this to a jury, the statute says you can't be sued for that, so we're throwing the case out. So that's a really important.
And that is,
Is that the same? You remember the Utah Horse Council years ago with selling signs? Is that the same sign? I would guess so. Yes. Okay.
but even like that, that's when I get a call from the county saying, well, how can they sue us if we have that? Unfortunately, you're going to get a plaintiff attorney. They'll still file a lawsuit and it still costs us a little bit of money. I should say a little. $25,000 is a lot of money. They still have to go through the routine and getting it dismissed off the record. So it can be frustrating. But okay, that is it. Thank you. I was waiting for an applause, but if you did that, so at least get really secure. It's standing ovation. That's all.
I'm glad you guys gave